a 1 minute as you all settle in, and then I'll be back to introduce our moderator of the day. So let's get sharing that link and tell a friend that we have gone live and we have started the session. Thank you. All right. So once again, ladies and gentlemen, it's our pleasure to welcome you to this wonderful webinar session. It's an incredible day here at the East Africa Law Society because this afternoon we have a very important discussion on the evolving landscape of insurance law, and we'll be looking at the legal insights, risk management, and emerging trends in Eastern Africa. The session is being streamed live on Zoom and our YouTube channel at East Africa Law Society. So I implore you to follow through on YouTube or share the link with a friend who may be interested in joining this session. We are privileged to have a very distinguished panel that will be introduced later. But for now, ladies and gentlemen, it is my absolute pleasure to introduce the moderator for today's session. Please join me in welcoming Ms. Effie Sheila Acheng, a distinguished legal professional who holds a Bachelor of Laws, diploma in legal practice, and is an LLM candidate specializing in public international law and human rights at the University of Nairobi. As the head of strategy and litigation, Ms. Effie brings extensive experience in insurance law, legal compliance, and dispute resolution, having represented clients across the Court of Appeal, the High Court, and the lower courts of judicature. With her expertise in legal audits, commercial litigation, and strategic advocacy, Effie is perfectly positioned to guide our discussions today, ladies and gentlemen. So let's give her a warm virtual welcome. And and let's drop those emojis in the chat room welcoming Effie. Effie, I'm going to hand it over to you. You have us for the next 2 hours. Hopefully by 4 we are clean and dry. So over to you, Effie.
Thank you very much, Gabriel, for the warm introduction. My name indeed is Effie Sheila Acheng, an advocate from Kenya. I'm glad to host a panel that is more distinguished than I am. But to set us off today in our topic, which is evolving landscape of insurance law, the legal insights, risk management, and emerging trends, is Francisca Kakuza from the Insurance Regulatory Authority of Uganda. Part of the things that we hope that she can, as well as the speakers, bring into the play is the place of insurance in East Africa. What is the technology changing, looking like? What are the various laws that are merging together in terms of East African landscape? What is the changing society, the changing economy? How does that affect insurance? Is the uptake in insurance necessitated by the various laws that have come into place that have made issues like fraud or AI more stringent? So we are hoping that from the panel and from the keynote speaker, we can learn something that a number of advocates will tap into in the East African region in terms of insurance law, because you will agree with me that insurance law has been looked at in a very linear manner in terms of every country looks at the law per country. So in Kenya, for instance, a number of people look at it in a accident claim manner, but there's a broad perspective of insurance out there that we need to open our minds to as legal practitioners. So that is where the place of legal insights come in today. And to begin us off in this very interesting conversation is Ms. Francisca Kakuza, Legal Secretary from Insurance Regulatory Authority in Uganda. She will give a keynote address. After that, then we'll introduce the panelists. Ms. Francisca, if you can hear me, please. Thank you. Yes, we can now.
Hello.
Yes, we can hear you now.
Yes, Effie, just give me 1 second to arrange my light and myself before I present myself to this gallant audience. Just a minute.
Very well. As you arrange your light, members, please feel free to drop any concerns or comments or questions on the chat session. The chat session is at the bottom of the screen. It's available for questions, and the panelists and presenters will take the questions after their presentations. In case of a very burning intervention that cannot wait, then you can also indicate that on the chat session, and you'll be able to just bring it to the attention of the speaker. Again, we want to also ask you to invite your friends by sharing the link and sharing the poster, so that a number of us as can benefit from today's session are able to benefit and get to know what is the place of the insurance law, how is the landscape evolving towards that. On a personal perspective, as Ms. Francisca prepares, having worked in insurance industry for over 5-6 years, I started working at insurance industry when I was still finishing campus and the School of Law. I have seen various landscapes evolving. The first thing that has always been something that I look to is the place of the law. For instance, we have Insurance Regulatory Authority, and perhaps Francisca will address this in Kenya and in Uganda. Do they all work together such that if there's a claim that perhaps Kenya and Uganda do not agree on the circumstances, where would that be raised on? What does the advocate do if you're representing somebody in Kenya and the accident occurred in Uganda and the parties cannot agree on the causation or the chain of the accident? Do you take it up with IRA in Kenya, who then take it up with IRA in Uganda? Those are some of the things that perhaps you can bring to us. Thank you, Francisca. I see you're well set. You're on mute, Francisca.
Technology. So yes, Effie, I was just saying that I hope you can see me. I've tried to adjust my light in the background.
Yes, we can see you and we can hear you as well.
Okay, thank you. Thank you so much. Thank you. Colleagues, my name is Francesca Kakoza. I just want to say thank you to the East African Law Society, first of all, for inviting me to give this keynote. I'm honored to be speaking to an audience of both advocates and insurance enthusiasts. Thank you so much for signing in, and I hope that we're going to have a very interesting conversation around insurance, the evolving regulatory landscape, and of course, the things that are causing that change. So to our audience, just to confirm that you can hear me, just to confirm you can hear me, just give me a thumbs up so I can confirm and then move on into the discussion. The 82 people that we have here, just give me a thumbs up for me to know that you're listening and you can see me effectively so I can begin my presentation. Okay, Effie, I'm not seeing any thumbs up, but I'm sure they're coming up in the chat. And please feel free to keep that moving so that we get your questions as we go on. Like I said, Francesca Kakoza, I'm the Director Legal and Secretary to the Insurance Regulatory Authority. I'm an advocate too, and I have over 17 years experience in legal practice and advising boards. I'm also a chartered governance professional and have a diploma in insurance from Insurance Training College. I've been advising boards and management for over 17 years, like I said, across the financial services spectrum. I've moved from banking, gone to microinsurance, done development finance, and now my stop is in insurance. And I found the industry very, very interesting and challenging because every day you keep getting new issues that are coming up, especially in the consumer space, but also insurers have their issues and third-party service providers. So as we discuss this, let's keep that in mind. So in today's session, I'm just going to tackle over 10, and those are 10 slides or so, just to ensure that you'll be with me. We'll go into an introduction on why insurance law is evolving. And then we'll look at the key drivers of this change in insurance law. We'll look at the global and African trends in as far as they also trickle down to the East African insurance industry. We'll look at legal responses to a changing environment. Of course, the evolving legal doctrines in insurance. We'll also look at risk and compliance in this new era of an evolving insurance landscape. And we will finalize into the regulatory trends in East Africa, and then how you as legal advisors can then prepare for this changing environment. Effie, just to confirm, how many minutes do I have? I know how to go off. I just want to make sure I know my time, so I work within it.
You can take at least 15, say 15 to 20 minutes.
15 to 20. Okay, I'll negotiate when the 20 are done. Yes, so like I've said, we have those key elements to discuss as we discuss the evolving landscape of insurance law. And I'll start you off with a very famous gentleman that we all know, and most of us have given this name to those clever students in our classes, Lord Denning. And this is what he said: the law does not operate in a vacuum. Now, this particular clause or statement was said in the famous case of Central London Property Limited versus High Trees House Limited. As you all know, this was a case on promissory estoppel, but this particular principle is so applicable even today because the law does not operate in a vacuum even today. Once the environment changes, once society changes, the law will change. And definitely when there are changes in climate risk, when there are changes in technology, when there are changes everywhere, us, the regulators, will definitely come up with regulations to guide those particular elements within our industries. So I would like for us to keep this statement from Lord Denning at the back of our mind as we move on. So like I've said, insurance operates at the intersection of regulation, risk, and society. Now, the insurance industry, as you know, insurance is a risk transfer mechanism that requires a lot of trust between the insurer and the insured. There are various legal principles that have been developed to govern that relationship, but the basic still remains. Insurance operates at the intersection of regulation, of risk, because it's a risk transfer tool, and it's all about risk and de-risking your life and your livelihood, and of course society, which are the consumer of insurance. So any changes in these three aspects, in regulation, in risk, and in society, will definitely change insurance. And like we've said, the law does not operate in a vacuum. Once the insurance landscape changes, the law will also revolve to then take consideration of those particular changes in the industry. Then, of course, like we've said, as our social and economic and environmental contexts change, so must our legal frameworks. And as you may know already, the East African region stands at the cusp of transformation, and there's already a lot of innovation, a lot of economic expansion, because our economies are growing, as we shall see. And of course, once an economy grows, then the need for insurance becomes even more pertinent. As you may have heard, in Uganda, for example, we are already, our oil production is going to begin or began. Okay, and of course, with oil extraction, there are risks involved. And once that landscape, now our insurance sector has been, oil and gas risks have been added to the spectrum of our insurance risks. And of course, our regulations have to change then to follow that landscape. Now, this session will explore those particular changes, how the legal frameworks are adopting, and how to stay ahead, how you as legal advisors and counsel in the insurance sector can actually stay ahead and ensure that you're bringing value to your clients, whether they are insurers, whether they are regulators or customers, or even insurance intermediaries. Okay, so let's just look at the global trends that are shaping legal change. And as you may know, these global changes, when you see global changes happening elsewhere, just know they are going to flow into what we do in East Africa. You may have heard of things like IFRS 17, and we'll go into that deeper in the presentation. Of course, the International Financial Reporting Standards body brought out that for us. It didn't just end there. It has now flown into East Africa, and there's a lot of changes going in there. But so let's just look at the global trends shaping legal change in Africa. Now, according to the Swiss Re report, the Sigma report 24-25, global GDP growth is at 2.8%, is estimated to be at 2.8% at the end of 2025, and in 2026, 2.7%. Economic expansion, like we've said, of course, links into insurance and how insurance is underwritten, and of course the size of premiums, because then that means you're underwriting bigger risks. Then life insurance is estimated to reach USD 4.8 trillion by 2035. Now, you all know about life insurance, I hope. That is insuring your life against various risks: death, permanent disability, temporary disability, and anything that can happen to you. So life insurance is estimated to reach 4.8 trillion in 2035 globally, but also in Africa, we've seen that life insurance is actually growing at a much higher rate now than non-life insurance. And non-life is the one that has all those other non-life risks that are insuring: the cars, property, goods, all those things are considered non-life. Now, non-life profitability is also increasing. And of course, but what then made the change, or was the game changer for life insurance, was COVID-19. From 2020 to when the last COVID-19 cases, of course, they're still there, but when COVID-19 ebbed, we saw an increase in life insurance, because then people were thinking inward and saying, you know what, I must protect my life because of the many deaths that were around us. So we saw an increase in life insurance, both globally, but also in East Africa. So that is the change. Non-life was the big boy before, but now life insurance is also started growing during COVID-19, and it's continuing to grow. Of course, globally, there is focus on cyber risk, marine, and of course, political risk. As you may have seen, of course, in Africa, we've got a lot of, there's a lot of disturbances, political disturbances going on across the various countries in Africa, and in East Africa, intermittently, we tend to see those. So political risk globally is one that is very prevalent, and of course, insurance follows risk. Cyber risk, as you may have seen, AI, big data, data analytics, Internet of Things, all those things have changed the landscape. And of course, we are following as insurers to see where the risk is so that we can provide the right products. And of course, the push for transparency. Globally, there's a lot of push for transparency in the way business is done, not just for insurers, but financial institutions. As long as you handle consumers, there's been a big push for transparency. Now, all these are shaping the legal change globally. On the African continent, again, there's a lot of changes that are happening, and of course are changing the regulatory environment. Remember Lord Jennings' statement: the law does not operate in a vacuum. We now have African countries focusing on various strategic priorities, and those include digital transformation. I'm sure you've heard of AI, you've heard of blockchain and all those. Of course, microinsurance. Now there's microinsurance is being prioritized as a focus area for all insurance sectors, whether it is East Africa, regionally, there is a focus on microinsurance because of the need for inclusive insurance, ensuring the low-income earners and ensuring that their lives are de-risked, but also because de-risking the lives of low-income earners is also good for our governments. Because remember, most of us as regulators are, of course, government organizations, and government's interest is in its people, not just the high income, but the low incomes as well, income earners as well. So microinsurance is a critical one. Mobile money integration. There's a lot of development in mobile money. We have M-Bima in Kenya, although that's mobile insurance, but also there's been a lot of integration between insurance companies and mobile money companies to see how they can deliver insurance quicker to the public and to their clients. Of course, health and agriculture insurance, very critical. We've talked about COVID-19, and so health insurance comes in very prominently. Of course, agriculture insurance. Most of our East African countries rely on agriculture in some way. In Uganda, it's prominently. In other countries, it is really the same story, although there's a mixture of dependencies there. But because of that dependence, health insurance and agriculture insurance have become very prominent. Of course, climate resilience, you may have heard of climate risk financing, climate risk insurance and whatnot. And that is because of the vagaries of the weather and what it can do to our economies because we rely on agriculture. A simple storm can destroy agricultural products or crops in a farm and lead to disasters in various areas, or even drought, as happened in Kenya, and many others. The locusts, remember the locusts, and all those particular climate changes have caused havoc in our populace. And so there's been a need and a drive to put insurance products that can actually lead to climate resilience. Of course, regulatory compliance is a strategic priority. Consumer education, and I want us to keep all these strategic priorities in mind because they're not just for Africa, they also flow into East Africa. Like we said, once these strategic priorities happen in our governments, then the next change is the regulatory landscape. Okay. Then of course, fintech partnerships is another area that is driving a lot of change in insurance because of partnerships between insurance companies and tech companies to ensure across the insurance life cycle, from product development, underwriting, onboarding of clients, claims management. There's been that integration between fintechs and insurtechs, insurance companies and tech companies, to ensure that they deliver to their customers very quickly, and also their processes are more efficient and excellently done. Of course, data analytics, our insurance industry is one of those industries that uses a lot of data to be able to determine customer preferences, even just customer risk profiles. Our insurance industry uses a lot of that. And so, as you may have seen, our insurance companies are also engaging in a lot of big data analytics to help them make decisions. And of course, personalized insurance offerings. Remember the legacy products that we used to have, those ones of comprehensive. So I don't need comprehensive insurance year-round, but I'm forced to pay premium for the whole year because insurance wants annual insurance contracts. And yet there are people that have moved ahead to say, no, I need comprehensive insurance for just 1 month. And those personalized insurance offerings are being done across the globe. They may not have linked into our African markets, but they are coming. So these are more personalized. You go and the insurer assesses what your risk profile is and then is able to offer you a product that is good for you. And I'm sure that will avoid things like, this is not the risk that I intended to insure, especially when it comes to claims management. So these are the strategic priorities across the African sector, African region. I just wanted to show just a sneak peek into what's happening in the rest of Europe. I was very amused by this presentation. This was a report done by one of the I forget the name, one of the researchers, I don't know if it's McKinsey or one of them, anyway, they were exploring Gen Z's insurance preferences in the Netherlands. And this is what they presented. I was so amused by the fact that Gen Zs are not looking at these are their priorities, first of all, in the Netherlands. For them, it is more Dutch Gen Zs think more about the future than their parents, firstly. They have a need for rental insurance and less for home insurance. Now, whereas us, we are looking for home insurance to insure our homes and what is contained there. For them, they're looking for rental insurance because they don't have enough money to be able to go out and buy a home and therefore insure it. Then, of course, they are more inclined into purchasing insurance via mobile apps and the internet. You will not tell a Gen Z to come to insurance companies or send them an agent to sell to them insurance or expect them to go to a broker to sell them insurance. For them, they want easy things, mobile apps, internet, etc. That is what they want, to be able to buy insurance. And then the way they make the insurance decision is also amusing because they're not relying on available information or how useful this insurance is. No, they're looking at the opinion of friends and family is important for them to be able to buy insurance. So I just wanted to throw that out there for you to see the changing landscape, because we do have Gen Zs in East Africa and there's something else they're looking for. They're not looking for your traditional insurance. So just as we've looked at the changes that are driving, the factors that are driving change on the African region and globally. Now let's zoom down to the East African insurance industry. And I just wanted to give you an overview of who we are in East Africa. And to respond to you, Effie, you asked about whether we have some kind of harmonization going on across East Africa. Can we, if a matter happens, if a risk occurs in Kenya and it's caused by a Ugandan person or, happens across, can we take care of that? So just to inform you, we have a body that we call the East African Insurance Supervisors Association. This body brings together regulators from all the East African countries, the 7 East African countries, and they just recently last year approved their strategic plan, and there's a lot of plans in there for the East African insurance sector. There's a lot of harmonization that's going to happen in terms of our laws, but also in terms of supervision of our insurance companies, especially those that have global reach, is also going to be harmonized, if not already harmonized. So there's a lot of harmonization going on, and even in handling of legal matters across. Yeah, so just to talk about the East African insurance industry, to give you an overview, there are positive growth drivers. Like I've said, everything that's happening on the African landscape or global landscape is coming into here. So everything, all the strategic priorities I've talked about in Africa and also in East Africa. But particular to East Africa, of course, there's rising public awareness for insurance and its use to de-risking lives and livelihoods. There's a lot of regulatory reforms and risk-based supervision. I'm sure you will have heard of risk-based supervision and especially what it is. This is previously what we used to have is compliance-based supervision, where we're saying the law says this, you must comply. And so insurance companies were then called upon to comply with what the law provides for. Now we're looking at risk-based supervision, where we're going to regulate a company depending on the risk it's exposed to. So in there, we are looking at solvency ratios, at your capital adequacy, at your governance as an institution, especially for those that are what we call the big players. We are looking at them and then regulating them based on the risk they are exposed to. So of course, technology adoption, a lot of it happening in East Africa in terms of insurtechs and mobile platforms. Like I said, up there for the Africa, the mobile insurance company integration is happening a lot, and of course market diversification. We have key challenges in the insurance sector, even as I go into what is changing in the legal landscape. There's low insurance penetration, Our penetration in East Africa ranges from 1 to 3%, with Uganda being just short of 1% and Kenya having the biggest insurance sector at 3% and growing. Of course, there's a lot of economic volatility and inflation in our East African countries, and any changes in the economy will, of course, affect consumers' purchasing parity, but also their the insurer's ability to pay claims. So that is still a key challenge, although there's a lot of good things happening in our economies as well. Of course, regulatory fragmentation across East African countries, like you mentioned, Effie, we each have our own regulatory frameworks. But that said, there's been a lot of attempt at harmonizing these regulatory frameworks. Firstly, by introducing the East African Community Insurance Policy. And for lawyers here, that is a very critical document for you to look at so that you see where insurance is going, so you can then change yourselves or at least grow your capacity to provide the required support in there, because lawyers and the insurance industry, we are together. We are not going away from lawyers. We need lawyers. Yeah, so a lot of changes, but our different countries have different regulatory frameworks. Now, in terms of, like I said, East African insurance policy is there, and most of our countries are moving to harmonize. Most have harmonized, but most of us are also moving to have national insurance policies approved so that then we can start tapping into the developing areas in insurance, in ensuring the insurance sector. One of the key things in the insurance, East African insurance policy, of course, has oil and energy transition. As you know, there's a lot of energy transition that's happening globally, but also here, to move to greener energy sources, from oil to solar to hydro to all those other green sources of energy. So that is one of the areas that insurance is going into. And so as lawyers, you definitely need then to educate yourselves about this East African insurance policy, see where the opportunities are, and then plug in. But that said, apart from the insurance policy, on the East African platform, there's a lot of harmonization also going on by the East African Insurance Supervisors Association. We have various committees that are working on harmonizing our regulatory framework, on harmonizing our supervisory framework, having peer reviews so that we are able to do peer reviews of each other and see where lack of harmonization is. And then, of course, our harmonization with the insurance core principles. Again, that's another document that you need to educate yourselves about insurance core principles, because they link a lot into the regulatory changes here. So that is the East African insurance industry overview. Like we said, GWP growth, Kenya leads, followed by Tanzania and Uganda. However, growth varies by different countries. So Uganda might be growing at, say, 5%, Kenya is at 2%, Tanzania is at 3%, etc. But Kenya is leading in terms of gross written premiums growth. In terms of insurance penetration, I've already talked about that. The countries are like that. And then, of course, claims ratios across the industry are increasing due to climate events. Like I've said, floods, drought, any storms, earthquakes, anything that affects any of these climate vagaries can greatly affect the insurance landscape. Because remember, once floods come and people's properties are destroyed, the next person they run to is their insurer to compensate them, because you promised you will be the friend in need, the friend when the storm comes. This is this. Then insurers, of course, are investing in better claims processing and fraud detection. As you may have noticed, there's been a lot of fraud in our insurance sector, with people intentionally causing risk events so that they can claim from insurers. We've had those that have pretended to die, they disappear. People come to claim on a life insurance policy only for the insurer to investigate and find out that the man, usually it's a man, sorry, but the man is hiding deep in their village. They did not actually die. when here in town, there's actually a grave that is engraved on and the person died. So there's been a lot of fraud. And of course, insurers are investing in fraud detection. At the Insurance Regulatory Authority, we also have an anti-fraud unit that is ready to prosecute insurance fraud, any fraudsters that we get. We got authorization from our DPP, Director of Public Prosecutions, so we have that already in place. And of course, insurers are also investing in claims, improving their claims processing, because this used to be the biggest issue that used to bring our sectors down. Insurers used not to want to pay claims. And so as regulators, we have moved ahead to put in place mechanisms that encourage but also enforce claims payment, especially when that claim is due. In IRA Uganda, we have a complaints bureau where we've provided an environment for the insureds to come and complain if an insurer is not paying a claim. And so far, we've seen growth in claims payment because of the Insurance Complaints Bureau, but there's also a lot of awareness now from insurers that actually when you pay claims, you increase your business. So most insurers are investing heavily in this. Now, we've talked about this already, so I won't go into it. Like I've said, what's driving the change in insurance law in East Africa? Insurance law follows the environment. What is changing in society? What is changing in the risk ecosystem and profile? Remember the strategic priorities we talked about on the African landscape? Those are what's changing these things in East Africa as well. Of course, peculiar, but maybe not so peculiar to East Africa is that we have a rise of the middle class in Kenya, in Uganda, in Tanzania, in Rwanda, in DRC, Somalia, as well as South Sudan. There's this rise of the middle class, and the middle class wants to de-risk their life and their livelihood. And so they're more interested. You realize these are more educated people. And so they've seen what not having money in a particular situation can do to you. They were exposed to the vagaries of COVID-19. They saw the advantages to those that actually had health insurance. So this rising middle class is affecting a lot the changes we are seeing. And of course, now that links into the rising consumer activism, especially on claims payment and on insisting that their peculiar risk is the one that is insured by the insurer. As you may have seen, that we've now, in all our East African countries, we have come up with consumer protection guidelines and regulations. IRAs, we have them in different places. We have complaints bureau guidelines that are aimed at consumer protection, but also our licensing and governance guideline regulations are also focused there. We are now developing specific consumer protection regulations. In Kenya, you already have those. Tanzania already has those, and Rwanda is also moving to that. So there's a lot of development in consumer protection, and of course, it's linking into development of laws and regulations in those countries as well. Regulatory reforms, we've talked about the risk-based supervision. This has caused changes in our different prudential regulations across the East African countries, in Kenya, Uganda, Tanzania as well. Because of risk-based supervision, we've then had to amend our prudential regulations to touch specifically on this. What capital adequacy requirements will we require of the bigger players, and of course, what solvency requirements will be required amongst them. So all these are linking into the way we regulate. Of course, digital transformation is also linking into the way we regulate. Here in Uganda, we have the Data Privacy and Protection Act, which we are relying heavily on. But of course, across Kenya, Tanzania, they all have data protection acts and laws, Rwanda too. And so all these now are being utilized by regulators to ensure that insurers are complying, especially when we go for inspections. And we are now, in Uganda, we are moving to develop specific ones, specific regulations that are related to ICT and digital transformation that will touch on AI, on insurtechs, on mobile partnerships as well. In Rwanda, that development has already been done. They already have They already have ICT regulations, and they've also moved ahead, of course, in terms of ESG and climate-related disclosures. They've moved ahead now to have regulations or guidelines that are touching on climate risk disclosures, but also financial statements disclosures. So all these are coming up because of the move towards environmental, social, and governance matters and climate-related disclosures. In Nairobi, you have the Nairobi Declaration. I'm sure that Nairobi ESG Declaration for the country. So that is weighing heavily into the way insurance is regulated. In Uganda, we are developing our ESG strategy and framework. Tanzania is also on board. So as you can see, all these things are driving the changes in insurance law in East Africa. Digital transformation, ESG and climate-related disclosures, consumer demand for trust and transparency. Like we said, that is coming from the rise of the middle income, economic expansion and economic growth within East Africa. Like I mentioned earlier, in Uganda, we are mining, we are extracting our oil. And so, of course, that is going to lead to huge economic growth for us. But as the economy grows because of those other factors, then the risk profile increases, and we will have to come in to see what we can do there as insurers. And lastly, the regulatory reform and risk-based supervision, which are happening. Like I've mentioned already, East African harmonization is happening. Let me just breathe at this point to ensure, Effie, that you're still with me and the rest of our audience is still with us. I'm riding towards the end. You're with me? Thank you.
Yes, we are with you.
Thank you for that. Yeah. So colleagues, we've looked at what's driving the change in insurance law in East Africa. Like we said, the law does not operate in a vacuum. All these changes are happening in our East African landscape. And so, of course, the law must follow. And like I've told you, the various regulators have developed these regulations or are coming up with them. Now, like we said, and I've already spoken about this, as the insurance sector innovates, legal frameworks evolve in response. Now, the emphasis once again is on transparency, solvency, consumer protection. And this is the big thing for us. It's a big baby for each regulator. How do we protect insureds and consumers? And the move now is to come up with consumer protection regulations that will link into protecting our consumers. And of course, courts have not been left on the side, by the way. There's a lot of stricter insistence on fair insurance clauses from courts. And there's been a lot of judicial activism that we've seen, especially in terms of protecting the consumers. And so courts are frowning on those exclusion clauses that we've been used to getting away with as insurers. We go and put an exclusion clause that completely destroys the insurer's obligation to compensate the client when the risk happens. And we've seen those cases even in the Complaints Bureau here in IRA. We've seen cases where policies are really crafted in such an unfair way that the clauses in there are defeating the whole purpose of the policy. You say you're insuring me against fire, and you're asking me to not bring fuels on site. For example, if I'm a mattress making company, you know that some of the components for mattress making is fuels. And so you go and say, as exclusion clauses, any fuel available on site is you should not bring any fuel on site, or you should bring this number of liters on site. Now, you know that my business uses so many fuels, and at a particular time, there's going to be a lot of fuel because it ties into what I make. And so when the fire happens, the insurers are refusing to pay because of that exclusion clause, because the clause said you should have only this number of liters of fuel on site. And so we've seen a lot of judicial activism towards removing those not recognizing those exclusion clauses, because they destroy the purpose of the contract. Of course, lots of legal transformations that we have seen. I've talked about them already, but let me focus now on IFRS as I conclude in the next few minutes. Colleagues, we've heard of IFRS 17. Previously, when insurers were using IFRS, they were operating under IFRS 4. That standard was more flexible and less stringent. Now, recently, as early as 2023, IFRS brought out IFRS 17, which is a very critical standards for insurers. And essentially what it's doing is it introduced a major shift in how insurance contracts are recognized and disclosed. It also, of course, brought challenges in terms of preparedness, the data systems, the data that is required, you know, in terms of to support the insurer to adhere to IFRS 19. I would really encourage us to read about IFRS 19 and its implications for insurers, because most of them are struggling with it and its application, and your legal interpretations and applications will come in very handy. Now, as the East African region, of course, this caused a lot of challenges to us, but as regulators, we moved ahead quickly to then train the insurers early, ensure that their systems are able to extract the required data to feed into the financial statements as they prepare them, and also especially in the way they recognize insurance contracts. So this one is a key issue for you to actually go to and ensure that you're educating yourself about IFRS 17. Very quickly, all these changes that have gone in, and I've spoken about these already, have changed the way we look at our traditional principles and legal doctrines. As you may have heard, insurance is a contract of utmost good faith on the side of the insured, but also the insurer. You must be able to disclose. When you come to the insurer to be insured, you must say everything surrounding the risk. Otherwise, the insurer will tell you, you did not disclose this, and actually, that will nullify the contract. Of course, like we've had, insurance is a contract of indemnity. It puts you back in the position you were in, no profit at all. You cannot get more than you had before you were insured. Of course, privity of contract and limited consumer rights. Those were our traditional insurance principles that protected the insurer. Now there's a major shift from all those things that I've talked about. Now we've had pro-consumer interpretations in courts of law. There's a lot of pro-consumer interpretations, interpretations that will protect the consumer as against the insurer, because they know the insurer has traditionally had the upper hand, but also does not want to pay claims. I talked about the judicial activism against unfair clauses, claims processing and exclusion clauses, and of course, the growing accountability for insurance agents and digital distribution partners, especially in as far as the duty of skill and care is concerned. As you know, as insurers, when insurers are selling insurance, sometimes they might not go direct, so they will have agents that they send out there. Now, these agents have usually escaped and gone off scot-free because they are not the principal. But now our regulations coming out are holding them to a much higher standard to ensure that they sell the right product, and to ensure that also themselves, they educate themselves a lot in terms of knowing what to do and what product to sell. And so these are just a few of the changing legal doctrines, traditional to modern legal shifts. And lastly, to my final slide, I think we've talked about these already, the risk and compliance implications. We've, from the landscape that is changing, you have noticed the changing and emerging risks, of course, legal, ESG reporting, climate obligations, there are compliance issues there in terms of KYC, in terms of how the insurer, KYC is know your customer. The insurer is required to find out everything about the customer so that then they're able to underwrite the risk. It will not be an excuse that I didn't get the information. Solvency, multi-jurisdiction regulations, those are coming, like I've said before, and Effie asked about that. Of course, operationally, IFRS implementation, data collection, and internal controls are very critical emerging risks that we must advise our insurers about. And of course, on the strategic emerging risks, the failure to adopt tech or address underserved markets for insurers, this is a risk that is being posed on our landscape, and insurers are encouraged, and you as legal advisors are encouraged to advise your clients about these particular risks that are coming up on the legal platform, compliance, operational, and of course, strategic. Now, lastly, what should you do what should you prepare for as legal advisors? You need to prepare for what's next. Understand evolving doctrines and sector-specific risks. Those in Uganda, we have oil and gas, and now the energy transition. I know that the Petroleum Authority has already been calling service providers, and most of our lawyers are registered on their database. But now there's the energy transition to greener energies, the solars, the hydros, the batteries, and all those. You need to understand these evolving doctrines and sector-specific risks so that you're able to advise. As the oil and gas industry, they're exposed to so many risks, environmental risks, social risks in terms of the communities surrounding oil pipelines and refineries, etc. So you must be able to educate yourselves about these specific risks so that you're able to advise. Construction industry, there are construction risks there. You must be able to advise on construction policies. Of course, build technical capacity in terms of ESG, IFRS, InsurTech contracts, and then monitor and contribute to the harmonization efforts across East Africa. Each of the regulators, when they're coming up with regulations, call upon the insurance sectors, but also you as legal advisors to actually contribute into these regulations and give your say. So we need you to be active in this harmonization. It's going to happen. Please get the East African insurance policy so that you know where the trends are going. And once you know, educate yourselves about those, and of course, monitor the harmonization so that you're able to advise your clients across East Africa, because most of our insurance companies are actually regional. So you must be able to advise them. And of course, guide clients through compliance complexity and legal innovation, because there's a lot of that going on. So you need to be able to educate yourselves and then guide your clients. So colleagues, I would like to stop this here. I've talked a lot about what you need to do. That is my call to action. Be proactive, be strategic, be regionally engaged as we navigate the insurance, the evolving insurance landscape. So let's shape our future and not just respond to it. Thank you so much, Effie. I hope I've used my time right and not disadvantaged you. But thank you so much, colleagues, for listening to me. Thank you.
Thank you very much, Francisca. I hope members would agree with me that that was a very in-depth presentation. That was enough to have a session of its own. We have done a little bit of injustice to your presentation by having you hurry through the points. But one of the things that has come up is the low-risk insurance penetration in East Africa. And I think that is one of the questions that in the beginning we had raised. So I'll just give you two questions on the chat. Can I read them to you or can you see them? There's a question from Eddie Kimanzi and one other question from Salim, who's asking, will this presentation be shared later? And there's Nanyunja in less than 2 minutes, so that we're not doing an injustice to the other presenters. Would you perhaps attempt to answer Kimanzi, who asks, can the panel expand on agriculture insurance? Is it that high risk for places that have perennial drought? And Nanyunja, who says, in regards to claims, to what extent do claims put an assured at an advantage in claims process?
Okay, thank you so much. Thank you, Sarah, and I'll start with that since it was the last and it's from a lady anyway. Yeah, so Sarah, I would like to assure you that assureds actually, or insureds, have an advantage. But this advantage is, of course, based on, firstly, the kind of policy that you took up, but also your ability to respond to the guidelines in the claims process. As you may know, when you notify the insurer of a claim, there are timelines. that have been given to you for you to notify a claim to an insurer. Now, if you don't adhere to those timelines, usually it's within, I think, 10 to 15 days of happening of the risk. If you don't adhere to those timelines, then you're causing yourself a disadvantage. And so when a risk event happens, please hurry and go and notify the insurer of the claim. Now, the other thing that disadvantages insureds is the claims documentation. If you do not submit adequate claims documentation, then do not expect that the insurer can then verify, assess that claim, and be able to pay you. So it's important that when you do that, when you submit or notify the insurer of your claim, you submit the right documentation depending on the policy that you took up. And then thirdly, if your claim is actually an eligible claim, let me say it that way, because it's based on the policy that you took up, then you're not disadvantaged at all. The insurer will pay. Now, the issue will come in if it's not an eligible claim and you haven't looked at the exclusion clauses that were in the policy, or if there are issues like deductibles, etc., you have not looked at that, because there's a minimum, this is a minimum amount that beyond which the insurer will not compensate. So if your deductible is, say, 1,000 shillings, if your claim is below 1,000, the insurer will not compensate. So it's important that as lawyers, as we advise insureds, we need, first of all, in the first stages, when you're taking up that policy, make sure that you as a client read that policy, but also if it's your client that comes to you, go through the policy and explains to them what it means. Because we've seen when we are looking at these cases in the Complaints Bureau, one of the key things that we see is that the insured does not actually read the policy. And so they are disadvantaged when it comes to claims. But if the insurance process is clear, then you will definitely not be disadvantaged. And like I've said in the claim statistics, claims payment has shot up. In Uganda, it's almost 50% of gross written premiums. And I know that applies to all the other countries. Then on the question of the presentation, yes, Salim, it will be shared. I'll share it with Gabriel. Then lastly, to Eddie's question, can the panel expand on agriculture insurance? Isn't that high risk for places that have perennial drought? Not necessarily, Eddie, because like I stated earlier, most of our East African economies depend on agriculture. And I'll speak for Uganda in particular. Agriculture is one of our largest economic drivers. And so we might not experience drought in all the places, but we have things like floods that happen, overrain and crops are destroyed. We have animals that might be attacked by diseases because we are also livestock. We also keep livestock in agriculture farming. It's not just crops, there's also livestock. Your whole kraal of over 1,000 heads of cattle can be destroyed by disease or any other animal, chickens, etc. You've heard about what happens, the analysis I'm using. Apparently, there's a breed of chickens when a sudden noise, loud noise goes off, they all die. They are that vulnerable. So you can find such things, not necessarily in high drought places, but in our normal households, you're a commercial farmer, you're rearing chickens, something happens and they all die. You will need agriculture insurance to compensate you. So note your question. It is not for perennial drought areas. It is for all of us across East Africa because we all rely on agriculture, some more prominently than others. Thank you, Effie. Over.
Thank you, Francisca. I think there are a number of questions coming in, but perhaps we can just take the questions as they will be coming in. We also give a chance to the other presenters. So at this point in time, allow me to bring on board the three gentlemen in the order in which they have appeared in the poster to at least introduce themselves so that members can also get to have a feel of who they are before they present. So in that particular order, that brings Mr. Mbaluto as the first, then Nassar, and then Mr. Alphonse. Just introduce yourself, what you do, so that members can also get to know you. And then we'll go back to Mr. Mbaluto to begin us off. And then in that order, Mr. Nassar and Mr. Alphonse.
Okay, thank you for that opportunity, Sheila. So my name is John Baluto. I'm a partner at the firm of Oraro and Company. I've been practicing law for around 17 years now. I practice as a litigator, meaning any disputes, but within that sphere, I've been handling quite a number of insurance matters. I'm also a qualified arbitrator. I'm a fellow of the Chartered Institute of Arbitrators. So I'm very pleased to be here and looking forward to the session.
Thank you very much, Mr. Baluto. Mr. Nasser, can you hear us?
Yes, thank you, Sheila. My name is Nasser Serunjoji. I'm a practicing advocate, managing partner, Magna Advocates in Uganda. I specialize in corporate and commercial, but I majorly do litigation and dispute resolution. I've been in practice for over 17 years. Thank you. I'm glad to be here. Good to see you all. Thank you.
If you cannot, I'm trying to avoid the second name so that it was a little complicated. So I stick to the first names. Let me bring on board Mr. Alphonse Gura.
Thanks, Effie. My name is Alphonse Gura, a practicing lawyer based in Zanzibar with Breakthrough Attorneys. Been practicing for 14 years. Now majoring in investment advisory, corporate and commercial. Thank you very much.
Thank you very much. Colleagues will be hearing from these three in a few. At this point in time, I see Mr. Baluto is ready to kick off. Mr. Baluto, in the interest of time, you can perhaps take at least 15 to 20 minutes. I hope you can work something within that time so that we can give the other presenters also a chance and get to do the questions at the end.
Very well. Let me see. Can you see the slides?
Yes, I can. And I hope the other members also can.
Okay. See, I just want to maximize the screen. Good. So my task today is to speak to some of the common sources of disputes within insurance policies, what causes them to arise, and I'll also look at case law that has arisen as the cases have been determined by court. So one of the most common causes of disputes between an insured and an insurer is one called non-disclosure. And as you heard Francesca say, an insurance contract is one that is based on a trust relationship, trust between the insured and the insurer. And it is implicit in that relationship of trust that there is something called full disclosure that occurs. So this is all material information being provided to the insurer as at the time of the policy coming into force, so that the insurer is able to make a decision as to one, whether or not they can actually provide the cover that is sought, and two, what premium to charge against this cover. So anything that disentitles or makes it difficult for the insurer to make this decision, an informed decision, will then fall under what might be deemed to be material non-disclosure. And in this regard, I've had the opportunity to deal with two cases touching on the issue of material non-disclosure, one being the case of Jack and Jill Supermarket versus Kenindia Assurance. Now, those of you who live in Kenya might recall Jack and Jill Supermarket. It was a very well-known supermarket in the old days, in the 90s. But at some point, it suffered a severe event whereby its walls were demolished by the landlord. And when a supermarket's walls get demolished, what happens is that a crowd very quickly forms around it, and there's looting that ensues by the crowd that gathers. So everything was looted, and the supermarket was, it was reduced to a mere shell. So Jack and Jill then sued Kenindia on the basis that, we're covered and we need you to compensate us for the loss suffered. But what had happened is that over the course of years, the relationship between Jack and Jill and the landlord had become extremely acrimonious. In fact, there was a change of landlord where a new landlord had come and bought the building from the old landlord and immediately took the position because of the amount of rent that Jack and Jill was paying, that they no longer wanted Jack and Jill present as a tenant. But that acrimony and that very tenuous relationship, the change in the risk profile, as it were, was not brought to the attention of Kenindia from year to year when the matter came up for renewal. And the assumption by Kenindia was that the relationship or the status that prevailed from the very onset, that, there's nothing untoward, it's a normal relationship between a landlord and a tenant, never changed. And it never had the opportunity to make an informed decision as to perhaps increasing the premium or perhaps deciding, look, this relationship between you and your landlord is too acrimonious, we don't want to get involved in the cover. So that being the case, the issue currently pending before court is whether this requirement for full disclosure to be made then entitles Kenindia to claim that there is no liability which accrues in favor of the insured. The other case that comes to mind, again, a case that I'm handling, is one called Consolidated Bank versus Jubilee. And all these are cases in the public domain. If you look for them, they will come up and you'll be able to read fuller. In this case, Consolidated Bank had actually been, it was an assured party within a life insurance policy taken up by one of its borrowers. So one of its borrowers takes out a life policy that is used as part of the bank's securities in the case of the borrowing, a life policy on the borrower. What the borrower unfortunately did in this case is that he did not disclose at the time of renewal of the policy. So this was the second year of the policy, that he had been diagnosed with cancer. Contrary to that, he actually signed off a statement of perfect health, saying that he's in perfect health, he's as fit as a fiddle, and there's nothing untoward regarding his health. Lo and behold, within 6 months of his renewal of the policy, he died of the very cancer that had been detected sometime during the first year. So the matter was placed under investigation, and it was eventually shown that indeed, as at the time of his statement of good health, he was seeking medical attention, and he knew very well that he was far from a fit person. So in that case, again, because of that material non-disclosure, the position taken by the insurance company is that the insurance policy is vitiated. So long and short, that's one of the major grounds for which disputes arise, one of non-disclosure on material matters affecting the policy. The other issue that commonly arises is that of exclusion of risks, sublimits, or waiting periods. Now, remembering that insurance covers a loss that is specified as a well set down risk that is identified. Sometimes, as it happens, there's a misunderstanding between the insured person and the insurance company as to what exactly is covered. One very common occurrence is that affecting, under medical insurance, that is, one affecting cancer patients, where oftentimes they think they are covered fully under the cover. Well, but if you sit back and you actually read in the fine print, you'll see that cancer sometimes is not covered, completely excluded, or it might have either a sublimit that is input or what's called a waiting period, that you can't immediately take up cover and then shortly thereafter be treated or reimbursed for treatment for cancer. You might have to serve a waiting period. So again, two cases which I have handled, that being one being the case of Kathleen Kabinga versus Jubilee Insurance and Nairobi Hospital. In this case, the insured was indeed covered. She had a medical insurance cover, and cancer was one of the stipulated, covered diseases. However, it had an applicable waiting period of 2 years from the date cover commences, to which you can then be covered for in the event of cancer, but other treatments could be covered within the start of date. So in this case, unfortunately, Catherine passed away for the very cancer, and the matter then went to court as to whether or not the applicable waiting period should be applied. Although the matter is heading to the Court of Appeal, the court actually found it to be an unconscionable contract on the part of the insured to have this as an exclusion. Obviously, the insurance company takes it very differently, that it is in black and white. If the insured did not want to be subjected to that 2-year waiting period, then she had no business signing up for that cover, and perhaps she could have looked elsewhere if she wanted immediate cover. So that's a case where there's a clear, departure or not reading from the same page as to whether or not the waiting period is applicable, although it was in black and white, and interesting to see what the Court of Appeal makes of this case. The other case that comes to mind is one that actually went to arbitration and then went to the High Court on setting aside of the arbitral award, and that was a case of Gladys Mburu versus Jubilee Insurance. And in this case, the issue was, again, cancer. A lot of the disputes that usually arise are unfortunately because of cancer. Cancer is quite a serious disease and ends up taking quite a bit of, medical expense and cost, which is why it usually comes up on matters such as exclusions or limits. Now, in this case, there was an applicable sublimit in that the entire cover for the medical cover was actually set at around 10 million, but with cancer being set at a sublimit of 750,000. And in this case, the insured person actually had to travel overseas. And by the time she came back, thankfully, she recovered. But the bill was enormous, almost the entirety of the 10 million. And so the issue that was before the arbitrator was, is it the 750 that is applicable as per the policy, or is it the upper limit of the 10 million? And the arbitrator held that indeed the cover ought to be as stipulated in the contract. So key thing there really is just to be very aware of what the applicable sublimits are, exclusions, or perhaps waiting periods that might be in play. Another major cause of disputes in contracts of insurance is one of fraud. And you heard Francesca give the instance of where somebody under life insurance is well known to be dead to the insurance company, and indeed there's a tombstone somewhere that marks him as such, yet is busy in the village going about his day-to-day business, his or her day-to-day business. So that is a classical case of fraud, which should obviously, just like any other contract, operate to vitiate the contract and result in its being set aside. One case which I'm aware of is one a rather sad one, called the estate of Eric Makau Musyoka. So in this case, the deceased had actually taken out a life insurance policy, but unfortunately, soon thereafter was murdered. And the investigations then showed that the beneficiary, the person who stood to benefit under the life policies, and who was actually related to the deceased, was implicated in the crime. He was waylaid on the road as he was walking home by a bunch of goons. And when investigations were done, like who set you out on this job, they all pointed a finger towards the very person who stood to gain under the life policy. So that account, the policy was voided, as I think the law is quite clear that a murderer cannot gain under a life insurance policy, and also the Latin saying that you cannot take advantage of your own illegality comes into play in that case. Francesca as well talked about the lack of supporting documents, or actually what you're doing when you're submitting or collating this document is trying to prove that this event which you as a insured person was insured against actually took place as contemplated under the insurance policy. So indeed, there is a need, there is a strict need that in support of your claim, you should be able to set out or submit the documents or the proof to show that this actually took place. So in cases of accidents, obviously what you need, some of the documents you need to come up with is a police report or an abstract that clearly allocates blame as to who was on the wrong in the case of a traffic accident. If it's a fire, you obviously need then an investigation or report to come out clearly as to what caused the fire. Was it accidental? Was it perhaps a case of negligence? Or sometimes even arson, because obviously, again, just like I said previously, you cannot take advantage of your own actions or wrongdoing to gain. So if it's a case of arson, you touching your own premises so that you stand to gain, obviously that policy would not come to your benefit. So the idea is that you must have such documentation or such proof as the case will require in order for your claim to be satisfied. The lesson which I need to impress is that you need to undertake these investigations or this collating of evidence as soon as possible post the event as can happen. Do not wait for too long after the event to go back to the scene of the accident, or perhaps if there was a fire, to try and start rebuilding or retracing what happened. And unfortunately, I did handle such a case where, and it's a case of Uzuri Foods Limited versus Occidental. And this case concerned the collapse of a silo, which collapse happened in unclear circumstances. And those were the words in black and white, that it was not known clearly what happened. And all that the insured could do was to provide possible hypotheses as to this silo might have collapsed because of scenario A or scenario B. But it was all, unfortunately, hypothesis, because, and this was notwithstanding, people actually died in the context of the collapse silo, because they were actually inside when this silo collapsed. And apart from the loss in shillings and cents, there was actually loss of life that incurred. But unfortunately, because no sufficient investigations were done when the collapse happened, by the time things were now, taking shape, the silo, the ground had been cleared. There was actually nothing. There was just clear ground, and it was not. No structural engineer could be engaged in to go and find out exactly what happened and what caused the collapse of the silo. So all we could come up with in this case was, as I said, possibilities as to what happened. Was it eyewitnesses and the people who had things came and said, I had the sound of an explosion, and then the silo collapsed. But is that sufficient to say quite clearly that it's an explosion that happened? Because one of the perils covered under that policy was explosions. But then again, it was a matter of conjecture and hypothesis, unfortunately, rather than strict proof that showed this is exactly what took place. So this is an example of the need to very quickly, upon the event occurring, to embark upon collation of proof or evidence in support of the event which what you contend is covered under the insurance policy. Another major source of dispute, as is common in most contracts, is just one of plain misunderstanding. You've not taken time to read the proverbial small print to acclimatize and familiarize yourself with what exactly is this contract all about. What are the rights? What are the obligations? What are the duties? And that's even assuming that you have this policy. Many a time, the first place when an insured person comes to me, I then ask them, where's the policy? And they look back at me blankly. They don't even have the policy to start with, let alone knowing what it provides. So it's very important, it goes without saying, that you need to read the fine print and familiarize yourself with it as an insured party, because I can assure you the insurance company knows it inside out. And the reason you need to do that is because there are some very strict contractual provisions, especially pertaining to payments, time within which certain acts ought to be taken, without which the claim is then void. And these are actually known as the Atlantic shipping clauses, after the case of Atlantic Shipping and Trading Company versus L. Dreyfus. It's an old case, 1922, House of Lords of England. So depending on the nature and circumstances of the contract, sometimes the period for specific actions being taken might be very short, but the court will not sit down and start rewriting and start saying, I think this period is too short, it should be longer. And in some cases, such as the one for Ascoff versus Sheed, Thomas and Company, the time stipulated there is 3 days. That within 3 days, you must take certain steps. Failure to which, it's voided. And if you don't like it, you simply don't sign up to it. And that is a strict application of the law. And we have argued this in one or two cases where cases are brought beyond what has been stipulated as a contractual provision for the carrying out of a certain action. I do think in the case of Gladys versus Jubilee, one of the issues we raised was that the time provided for lodging of the claim had actually lapsed. It had not been observed, and the issue was actually held in our favor. The issue of a time-barred claim being lodged. So very important to read. So what you need to avoid is scenarios where, although what you have before you is an insurance claim, you first have to perhaps go under the right to access information under the Constitution or the Fair Administrative Actions Act, asking for that policy to begin with. Then you read it and then decide where does this matter lie. Arm yourself with the policy. Whenever you finish negotiating and you have paid that first premium, thereby activating the insurance policy, always remember to ask for that policy because it's yours as of right. Obviously, if a dispute ensues, the insurance company might not be as forthright in terms of sharing these policies because they then know that you will hit them with it. So ask it from the very outset when the relationship is still rosy and you are entitled to it as of right. Delayed settlement of claims is another area of major grievance, perhaps actually cited as the most prevalent issue of concern, and the data from the IRA of Kenya shows that this indeed is one of the major grievances that insurance has as to exactly how long claims are being taken to settle. And a key case came up in the case of Direct Line Assurance versus Patience Mganga, although it was actually taken out by her administrators because she died in an accident. And the issue here was that, as you might well know, is that under third-party insurance cover, there's a statutory cap of 3 million. But by the time this matter was getting to the High Court, as it was, the court called upon to determine whether the Direct Line should compensate to amount above the statutorily prescribed limit. It had exceeded. It had gone to around 3.5 million because of interest accrued over time, with the insurance company, kicking the can down the road. So the court was called upon to determine whether or not, by virtue of the delay that the insurance took in settling this claim, it was obligated to exceed the statutory cap and settle. And the court indeed returned a verdict that the insurance company was the architect of the delay, and this delayed settlement was at its own peril, and it proceeded to compel the insurance company to settle the full amount, despite the fact that it had exceeded the statutory cap. So this is a call on all insurance company to settle the claims, those that are merited. Of course, there's no obligation to settle an unmerited claim, let alone settle it expeditiously. But those which are payable, particularly one that has gone through the rigors of court and the amount has been ascertained, and there's really nothing left other than settlement, then really there should be no delay in the settlement of such claims. Declined claims, of course, this is a matter of grave concern, but I would say that most outrightly declined claims are ordinarily declined for good reason. It is not that by and large insurance companies just refuse to pay for the sake of it. But there are those issues which I've just described right now: the non-disclosure, the excluded risks, the lack of documentation, and the fraud. So there's a lot of data around that. And indeed, by Q1 of 2024, IRA reported that the number of declined claims had risen significantly by almost 85%. And there's data that shows that it had risen by around 20 odd million. And that is just Q1 of 2024. So by the end of 2024, there's no doubt that would have risen by commensurate measure, given that statistics shared there. Also commonly happening nowadays, because of the advent of technology and automated payment, is one of erroneous. You actually make erroneous payments because the system is so automated. Either you've set up a direct debit to the bank, or you've you basically entrusted another third party, most commonly your employer, to deduct and remit on your behalf these insurance premiums. But lo and behold, what happens sometimes, it's not as efficient as you would contemplate. At times there are underpayments, other times overpayments, other times the payments are late, such that at the end of the day, it's, the premiums are all over the place, and it's unclear whether or not the policy is actually still valid by virtue of these erratic payments. So again, I had occasion to deal with a case, Mercy Wanja Nyamu versus Jubilee, where in this case, the plaintiff had actually taken out 2 life insurance policies, but the remittances were quite erratic. They were all over the place. Sometimes when one policy it had actually been overpaid, on another policy, it had actually lapsed, because if you don't remit regularly or as set out under the policy, then what happens is it lapses. The policy actually lapses. And if you continue making payments, they're actually forfeited to the insurance company under the lapse policy. So in this case, because of the nature of the client, being one of the clients who are very concerned about the policyholders that they serve, as well as my own advice, we took up a reconciliation exercise, and we are able to really come up with the amount which had been overpaid by the insured, and the insurer was then refunded of these amounts based on the fact that really it was not entirely her fault that these payments were being remitted in a very untidy manner. So rather than forfeit it and keep it for themselves, these monies were actually reimbursed, saved without any interest. So it was reimbursed interest-free. So those are some of the cases that I've personally encountered or I'm aware of. But I'd also like to mention 2 cases which affect the industry generally and pertain to IRA. One was the case of Muinde versus IRA, Muinde and another versus IRA, the 2022 case, and it involves the insurance company known as Invesco. So Muinde and his colleague had insured their vehicles with Invesco. And in due course, there were some accidents, and they were taken to court by the people who were involved in the accidents. And sure enough, judgment was entered or in varying amounts. Invesco, as an insurer, was then called upon to settle. But not only did it not settle, sooner or later, it then was placed under statutory management, meaning it effectively collapsed. So Muinde and his colleague then sued both IRA and Invesco under statutory management and said they had an obligation and they had a legitimate expectation that the moment they had insured their vehicles, both the IRA as a state entity and Invesco were obliged to ensure that these outstanding insurance claims were settled. And this was a regulatory responsibility which they were obliged to settle. And the court, the High Court that is, upon hearing the matter, actually agreed and condemned IRA. And this is very important. The regulator was told to meet all the decretal sums and costs and to take measures to ensure that Invesco now operates within the law. And so this was a shifting of the burden of an insurance company to the regulator by virtue of the fact that the IRA had failed to take its supervisory and regulatory mandate seriously, as a consequence of which policyholders were left exposed when claims ensued against them. So that's one case that I think would be remiss of me not to mention. The other case that was very interesting was an attempt by the IRA to regulate prices of insurance cover. So this was a case of Commission on Administrative Justice versus IRA, 2017 case. And the IRA in that case had come up with a circular prescribing the premiums which all commercial insurance companies should charge under motor insurance guidelines. So of course, they came from a good place. They were trying to regulate and make it more affordable so that the common man would be able to afford the motor vehicle insurance cover. But upon challenge, and courts are very good in assessing the limits of the mandate of statutory body. The court said, under what provisions of the law are you exercising these powers that you purport to exercise? And indeed, it was found that the IRA had no such power to regulate the pricing of insurance, and it should be a case of market forces informing what the insurance premium should be. And at any rate, I think the only entity that under law is authorized to do matters concerning price setting is one called the Competition Authority, not the IRA. So the court very quickly found that the IRA had acted ultra vires or in excess of its powers conferred under the act or the statute and struck down that circular. So what are some of the things that we can do in order to avoid claims or reduce at least their frequency? One is to use a simple and clear language so that there is no ambiguity as to what is being covered, what is the risk being covered, what are the exclusions, what are the sublimits, if any. Right? So let's avoid standard terms and conditions that may not be applicable to specific insurance policies and make it very curated and specific to the nature of the insurance cover that comes into play. As I said, avoid ambiguity, because in the event of any ambiguity, one of the rules called upon in resolving an ambiguity is what is called contra proferentum, which is a rule that says that any ambiguity should be construed as against the person who drafted the instrument. And many a times these insurance policies are obviously drafted by the insurance policy, so any ambiguity will be construed in favor of the insured and against the insurance company. Again, increase legibility and comprehension. Make it easy. Something easy. Headings. Deploy means that make reading an easier affair rather than making a document more complex. Clarify coverage and exclusions. Be explicit as to what should be covered and what is not. Avoid use of the word, for instance, may be covered. It is either covered or it's not covered. There are templates which are provided by the IRA, so it's a good idea to make use of them and fine-tune them rather than trying to, start from the beginning or invent the wheel. Specify timelines quite clearly for action to be taken, as I said. Those timelines, once agreed and signed off against, will be construed strictly by the court, no matter how short. They might be another indicator. There's a case where the time was given 3 days. The court simply was of the view, if you didn't like the 3 days, you should have said so, or you should have counter offered a more reasonable period. Of course, I heard Francesca very loud when she said perhaps there's a shift in the court's interpretation and there's a move towards a more consumer protectionism, but also courts are known to be purist at times, and they say it is not the position of court to sit down and start rewriting contracts. Once you have signed, you are of sane mind, you are able to pass it by your lawyer, and your lawyer said it's okay, you sign, then you'll be hard pressed to now start contending after the fact that it is an unfair term of contract. They review the policies regularly, obviously to reflect any changes in the law. This is more so to the insurance companies to make sure you're keeping up to changing, landscape, either regulatory or even in just the way business is conducted and the like. And lastly, as I said, don't forget to ask for your policy. This is for the insured person. Do ask for your policy document so that you're well armed with it. And when a dispute occurs, it is not the first time. You don't start looking for your policy when there's a dispute. You should have it beforehand. And that is all I would say for now. If there are any questions, I'll be happy to take them or perhaps take them at the end.
Very well. Thank you very much, Mr. Mbalito. That was a very clear and concise presentation. I think because of the interest of time, I know I have seen one question. Perhaps we can all take questions at the end so that we have the presentations. And then maybe somebody's presentation will cover the question. Then we're able to just see what remains at the end. But that was a very, very clear presentation. Thank you very much. So at this point, I'll also want to bring on board Mr. Nasser Serunjogi. I hope I at least tried.
Yeah.
So you have at least, say, 15 minutes so that we can also bring on board Mr. Alphonse and then take the questions at the end.
Sheila, I can see we have about 20 minutes to 4, but I'll try as much as possible to be brief because the previous speakers have actually touched on, some of the areas that I wanted to present on. So I'll only, highlight a few in the interest of time. But after that, I think I'll have to make a PowerPoint presentation, which I will share, and then it can be shared with the rest of the members. I'll straightforward go into, the backbone of insurance claims. The backbone of insurance claims and disputes, typically lies in understanding the relationship between the insured and the insurer. Once you get to the bottom and understand this kind of relationship, then the claims, the disputes will be less. The previous speakers have alluded to this already, that the relationship is one of utmost good faith, or what we usually refer to as contracts of abreme fidei, simply, meaning that both parties to this agreement must be honest with each other, and they must be true to themselves at the time of entering into this contract. So once the parties and everyone involved understands that principle, that this is a contract of utmost good faith, you must be honest and true to whatever representations you're making, then I believe that we shall have less claims and disputes. The process of this kind of relationship starts with a proposal or an application that is made by the intended insured. The insurer will normally provide a proposal form. It could be physical, it could be online or digital, but at least there must be, a proposal or an application that is made by intended insured. And in this kind of proposal, it has questions, that must specifically be answered by the intended insured. The reason why the insurer gave out, this kind of proposal is that it helps them in underwriting the risk. They need to know the nature, the type, and the gratitude of the risk that they're about to undertake. Normally, in insurance business, if the risk is higher, then of course, if the insurer is to take on that risk, you'll have to pay a higher premium. Okay, insurers usually do not want to take on high risks because it's a business for them. They are supposed to make money, they are supposed to make profits out of this. And where the risk is high, chances are that, you'll not make profits out of it. So they prefer low risks. So that's why there's this underwriting process where they ask questions and you give answers. And the answers given to those questions by the intended insurer must be accurate, except in exceptional circumstances where the intended insured unknowingly makes reasonable mistakes, then they could be excused. But other than that, then they will be held responsible for the representations, for the answers that they give. I will give an example. In a comprehensive motor vehicle insurance proposal form or application, there could be a question: where do you keep your motor vehicle at night? And you say, I keep it at my residence. Then the next question would be, is it a gated residence? Do you have a garage? Then your answer would be, yes, it's gated, I have a garage. Then do you have security? And then your answer is, yes, I have, security. So the insurer underwriting this risk now clearly knows that this is a low risk. The chances of, loss happening as a result of theft are very minimal because of these factors given. Now, you're involved into a scenario. I'll give an example. We are about to get into the Easter holiday. So you drive your motor vehicle to your village, you want to go and celebrate Easter with your family, there is no security, it's not a gated, environment and all that. And your car gets stolen or vandalized, during this Easter holiday. As the insured, you know that, your car has insurance, and the insurance company is definitely going to compensate you for the loss of your motor vehicle. Now, when you present your claim, they will go back to the proposal form, to the application, and, you know, refer to those answers that you gave. Now, that to them would amount to a misrepresentation, and it can lead to the insurer to deny liability and say, no, you told us this motor vehicle is kept, you know, in a garage, there's security, it's a gated environment. Whereas when the loss happened, this was not there. So they would argue that that was a misrepresentation. So what am I trying to say here is that there is need to understand, you know, the language that is being used, the questions that are being asked at the time of the application, okay, for everyone to be at the same page. Now, I would give another example. If for example, still on the motor vehicle, okay, the insurer would say in this policy that you're being insured within the radius of Greater Kampala, for example, okay? That loss or damage, you know, suffered within the radius of Greater Kampala is covered, because we need to understand the coverage provision and its exceptions, as the previous speaker stated about the exclusions in the policy. This is where the trick is. You know, because insurance is a business, and at the end of the day, they need to make money. So the trick is in the coverage provision, which we normally refer to as the insurance itself. The coverage provision and the exclusions. Now, it says that loss or damage, you know, that occurs within the radius of Greater Kampala is covered. Now, you drive your motor vehicle. Again, I'll give an example. In Uganda, you drive your motor vehicle to Kabale, and, you know, all of a sudden you suffer loss or damage. And you present your claim to the insurer, and they say, no, our coverage only limited to the radius of Greater Kampala. So while entering into these relationships, you must be very careful, you know, with the coverage clause. What is the insurance company covering and what are they excluding? Now, when you understand this at the time of entering into these relationships, then it will help to minimize the risk and hence optimizing the claims, because you will understand exactly what you're entering into. But as Francesca said, as the previous speaker said, many insureds do not read these policies. They do not even understand what they are getting into. Or even the lawyers who represent them do not adequately advise them. And that's why you see many times they will present claims thinking that they are actually covered, yet when you read the policy, you can clearly see that the claim that is being presented was excluded. So, number one, at the time of entering into, you know, the policy, at the time of making the application and the proposal form, we need to be very careful at the questions that are being asked and the answers that are being given, you know, for you not to fall into the trap of the insurer saying that, you know, you misrepresented facts here and there for them to have a way out and deny liability. Again, I would give another scenario of property damage, where you have, you know, property insurance and it is cover against fire. Ms. Francesca talked about this, where the cover is against fire and the insurance company will say that you're not supposed to bring gasoline at the property or the premises. Now, you will take out a policy and you know that you're being insured against fire, but the insurer at the same time says in the exclusion clause that they are not covering fire that is caused as a result of, gasoline. And you're not supposed to bring gasoline at the premises. And, so these are the terms that, they give with one hand and take away with another hand. But when you understand the language that is being used, and luckily enough, in Uganda, under the Insurance Act, Section 65 of the Insurance Act of Uganda, it provides for approval of text and format of the policy by the insurance authority. So when the insurance company comes up with a policy, this policy must be presented to IRA for approval on the text, on the language, on the wording, to make sure that the insurance company does not give with one hand and take away with another hand. So this is one of the measures or mitigating factors that has been done under the law to make sure that actually the policy makes sense. Otherwise, the insurer will try to play around, with the exclusion clauses to take away liability to that effect. And again, the previous speaker mentioned about this, that the language in the policy must be very clear. It must not be ambiguous, for the parties, especially for the insured, for them to understand exactly what they're entering into. Because if you have, a policy that is ambiguous, and then it's going to create misunderstandings. And that's where you're going to have, claims being brought up, because of the ambiguity in the language of the policy. But once the policy is very clear, and then I believe that we shall have minimal or minimum claims being presented. When it comes to dispute resolution or dispute resolution mechanisms, when claims are being presented, again, the insurance relationship is contractual in nature. It is between two parties or three parties where there is a third party. Again, I will go back to the wording and the language or meaning of some of the terms and conditions that are being used in these policies. Some of them do not mean, or do not take the ordinary meaning of a normal contract. They have technical meanings. And here you need to be very careful. However, in Uganda, again, I'll give an example of Uganda. Most policies, or all policies actually, they have a dispute resolution clause. And the Insurance Regulatory Authority issued a circular clearly stating or specifically stating, the dispute resolution clause, how it should appear in all policies. So the wording is the same that you'll find in each and every policy. But in summary, it states that in case of any dispute between the parties, then it is supposed to be resolved amicably first between the parties without the intervention of a third party. Now, what this means is that this is a contract that was entered into between these two parties, and they understand exactly, the assumption is that they understand exactly what they entered into. So it is best for them to resolve this issue amicably. And in most cases, as I have already highlighted, the dispute is about, the language, the wording, the interpretation. The policy usually has key major areas: the coverage clause, the definition page, the exclusion, the policy period. There are about 5 major areas, key areas that one needs to focus on. And you find that it is a matter of interpretation. Now, it is only when the parties fail to resolve the issue or dispute amicably that you can present your claim to the Insurance Regulatory Authority. Again, before you rush to litigation, before you rush to court, I think it is best, that you explore all the available remedies. You go to the Insurance Regulatory Authority, they will entertain the matter. If they make a decision and you're dissatisfied, then you can, proceed to the tribunal, the Insurance Appeals Tribunal, and again present your case. Again, when it comes to the claims management system now with the insurers, in order for us to optimize these claims and to have, justice and fairness, in determination of these claims, the process or procedure should be a straightforward process that is easy to understand. There shouldn't be, so much bureaucracy. The previous presenter from Kenya stated that, the non-payment of claims is on the rise. And some of this is caused by the bureaucracy in the process, where the insurer will, toss you up and down, and eventually, you give up on following up on that claim. The process should be as clear as possible and easy for the insured to make sure that they can follow up and be paid instantly. The delays in payments is another issue that has been addressed, because deliberately, some of the insurance companies want to take advantage of the ignorance and, illiteracy of some of these insureds. They want to take advantage and they don't want to pay. But where you have a clear process that is easy to follow, no bureaucracy, there are no games being played here and there, then it becomes very easy and you end up having, very minimal claims being presented. I'll give an example. In Uganda, we have motor third-party insurance for the motor vehicles. I believe it is everywhere in East Africa. However, many people do not understand this kind of insurance. Actually, many of them think that it is a statutory law that whoever owns a motor vehicle must have. They are not aware that this is insurance that covers loss or damage that happens to third parties. So you find that we need more consumer education and sensitization to the people to understand that actually, this is insurance and it covers any loss or damage that, could occur to third parties and all that. As the previous speaker said, we need more consumer education. In terms of claims processing, we need more partnerships with fintech. There should be digital, processes in presentation of claims by the insureds. There's an issue of timelines. It was mentioned again by the previous speaker. When a loss or damage occurs, you have timelines within which to present your claim. The reason why insurers put these timelines is because they want to investigate the matter before they make the payment or before they pay the claim. As already said, there are many fraudulent claims that are being made. So the insurer needs to investigate this matter when the evidence is still fresh. What needs to be done is to make the process, simple. Maybe, an online process where you don't have to physically drive, to the insurance company and make a claim. You can easily lodge your claim online. You can use an app, and present your documentation and everything. So that needs to be done. We also have an issue of the policy period. Again, this goes back to the understanding of the relationship and the policy. The coverage that is given by the insurer for the loss or damage that could be or might be suffered must happen within a specific period of time. So this is what we call the policy period, or the duration of the policy. Now, if you suffer loss outside that duration, simply you're not covered. But the question is the insured sensitized enough to know that actually I'm only covered for the loss or damage that occurs within this period that is stated? Again, you know, it's about the policy, it's about consumer education, it's about sensitization. I can see we have run out of time. Sheila, allow me to stop here and also give chance to our colleague to make his presentation. Thank you very much, colleagues. I'll try to, you know, make a PowerPoint presentation and share it with Gabriel and Sheila, and then probably they'll share it with colleagues. Thank you very much.
Thank you very much, Mr. Alphonse, for Mr. Nasa Serunjogi, for bringing the other perspective about, especially the Ugandan perspective. I think in a bid to understand the East African bloc, it is important for us to understand the different countries individually and then merge them up together. So thank you very much for your presentation, and we look forward to the PowerPoint when it's ready. At this point in time, I want to bring the last presenter, definitely not least, Mr. Alphonse Gura, the Principal Manager, Zanzibar Breakthrough Attorneys. Please proceed, sir.
Thank you, Effie. Being the last speaker, and I'd like to comment on what has been covered by my colleagues earlier. So I'll be speaking about cyber insurance and climate-related liabilities. A lot was covered earlier, but I will share from my experience. So when we speak of cyber insurance, of course, we are speaking about insurance that intends to protect businesses against financial losses, specifically with regards to cyber attacks and data breaches. And it's a growing aspect currently. The most important things to consider when we're talking of coverage, it's data breaches, as I said earlier, ransomware attacks, but also the interruption of normal business goals, and third-party claims as well, against lawsuits resulting from customers, vendors, and regulators as well. So in the East African region, and in particular in Tanzania, we have adopted the new law. In Tanzania, we call it the Personal Data Protection Act of 2022, with regulations that were adopted later. And there is a lot of compliance requirement, and as well, businesses face danger of infringement and security measures. So basically, it's important to understand for businesses that data is now an asset, and that can bring serious financial losses to businesses, and that calls for major reforms or insurance policies on data breaches. I tried to speak to a few insurance companies about how do they their portfolios on cyber insurance, and most of them they said many corporations that come and work in Tanzania, they come with their own cyber insurance from outside the country. That, in essence, it means that the product is still underdeveloped. There's low coverage on cyber insurance within the country. So, along with that, I should point out, specifically as a firm, we have advised closely related. We have advised on IDPs, insurance digital platforms. It's closely related to cyber insurance, and with IDPs as well, we still have we only have guidelines. We don't have regulations. Guidelines of 2022, and We have few players. Most of them are telecom companies. So far, we have only 15 registered. We recently advised on one. But this is also an area that's it's emerging in terms of cyber insurance. So that's one. I was also to speak about climate-related liabilities. I'll be very specific. Francesca spoke about the agricultural insurance. I love that. It was a good coverage. I've not advised specifically on that, but recently I advised in marine insurance, and that's one of the area that I think I'm well versed with. And it was the client advised. We had a very long negotiation with a number of insurance companies here, and it's an area that it's so much prone to climate-related liabilities. We had to cover so many aspects before we had the policy concluded. Physical risks more prominent, and you see specific. I'll be very specific to this client we have advised. Who brought a barge? It's a barge. It's a marine going vessel related to purposely for marine construction, marine transportation, and it's one of the largest that has ever been in Zanzibar. About 80 meters long. It came from a Dutch investor. So I'm bringing this up because the negotiations were so much revolved around the risks, and understanding of the risks was kind of alien to most of the insurance companies within the region, not only Tanzania, also within the region, because we also attempted to go across to Kenya. And so you see, we had to limit very much on the policy itself. Things that were which emerged: one, the weather condition within the region; second, the expertise, skills in operating the vessel, from the captains, from the engineers, from the cabin crew, was kind of low, and therefore, if there's any related liability, then you see the risks becomes high, and that pushed the margins for the premium. Infrastructure as well. Where is it for marine experts? They will know this. Bathing wall. Where is it parked? And that's quite of a challenge within the Tanzanian specifically. Then we went into the details of disclosing the kind of assignments it will be involved in. So you see this, it's meant for offshore and onshore construction, and that comes with so much risks. We speak about oil drilling, gas explorations, laying of marine cables, underground cables for electricity, for fiber networks, and such kind of cables. And also offshore construction in the islands, and carrying heavy equipment, because this is meant to carry equipment like cranes with tons behind. I'm just giving this for you to understand the whole idea of climate liabilities, climate-related liabilities. Because even the cranes themselves, you see, we had to go. What kind of cranes? How are they? What happens if there's a wind while transporting a crane along the sea? The discussion was prolonged, and at the end of the day, we had to drop so much within the policy so that insurance companies were ready to provide cover for the badge. But also one important aspect is that with marine vessels and climate-related liabilities, we have to speak about access to reinsurance market, and also a challenge because after seeing such a difficulty within our own jurisdiction within Tanzania, then companies had to rely on reinsurance market, and that was also quite a challenge because most of them considered the region, the East African region, as a high risk region when it comes to marine insurance. So perhaps some of policy people like Francisca can take that on board. I think in the interest of time, I don't have much to cover, but I also wanted to react on earlier presentation by Francisca. One important aspect that it's important to consider is Takaful insurance. I think that's one aspect she left out. It's a growing trend within the region, especially within Tanzania and Zanzibar in specific, because we have a large population of Muslims, and Tanzania has already issued guidelines for Takaful insurance. This is specifically for it's related to Islamic insurance, and the emphasis is on low premium, and also profit should be done away. So that's important also to take into account when discussing about the trends that are emerging in the region. With that said, please allow me to return to you, Effie. Being the last speaker, I think I have the advantage of having less time. Thank you a lot, Effie.
Thank you, Alphonse Gura. The advantage of having less time can also be construed as a disadvantage. Depends on which side of the insurance contract you lie. But thank you very much for the very well thought out presentation. I think you brought to perspective a number of things we didn't think about, like climate change and how that borders insurance. So at this point in time, I would want the speakers to address the questions pending. I see one question has been answered by NASA. NASA, would you want to, in a minute, just expound on that? And then the two open questions can be tackled. The two answered. NASA has answered the two. Perhaps you can just answer that verbally as well.
On the first question, I think the answer could be in having common wording or common language, especially on the coverage clause on the policy, the COMESA policy on all COMESA members, because that will avoid a lot of ambiguity in having, the different wordings or the text in the policies. Once the members can agree and harmonize on that, and then that will solve many of the problems happening. Thank you.
Thank you very much, Mr. Nasser. There's one open question. Do these legal risks, insights, and emerging trends also extend to the uptake of Islamic insurance? And how can legal personnel ensure they render proper services? Perhaps, I don't know whether you can take that, Francisca. Or Mr. Mbaluto, any one of the two of you can attempt to answer that.
So I think on Islamic law and its Islamic principles are very unique, and I must say I don't pretend to be an expert on Islamic law. Perhaps, Alphonse, given that I think Islam is more prevalent in Zanzibar, you might be better, please.
Yeah, that's a good question. I'm not an expert in Islamic law, but what we're experiencing in Zanzibar, a lot more of investors from Islamic countries like Oman, in the Middle East generally. And so it's important for legal advisors to understand this kind of investors who come here and the kind of insurance they would require. Underwriting, operation, investment-related risks are obvious there, and we already advanced also with Islamic banking. So I think there are some kind of coverages that we have to align ourselves as legal practitioners, liquidity risks, credit availability, and things like that. But yeah, well, I would say that for now. By the way, we have Islamic banking, a lot of Islamic banking, both in mainland Tanzania and more in particular in Zanzibar as well. Yeah. I hope that answers the question a bit. Thanks.
I know I'm the one who couldn't quite hear the last bits, Mr. Gura. But I think we understood the gist of your response. And at this point in time, again, in the order in which the presenters began the presentation, I will allocate just 1 minute each to every presenter to give the vote of thanks. Then we hand over to Gabriel to do the closing remarks. Mr. Mbaluto, then Mr. Nasser, then Alphonse, in that order.
Yeah, so thank you very much to all attendees for having lent us your ears over this afternoon. It was a great pleasure to share my thoughts together with my co-panelists and guided by the moderator. And thank you to the East Africa Law Society for organizing this. I am very grateful and I look forward to future engagements of a similar nature.
Thank you very much, moderator Sheila. Thank you very much, East African Law Society, and to all the other panelists and all the attendees. It's been a very insightful session for us. And what I need to emphasize is that, the bottleneck of this all is, to understand the policy. Once you understand the policy, then there will be less claims. So it's that simple. Just read and understand the policy. Thank you very much.
Thank you very much, Mr. Alphonse.
Yes, I'm also grateful to East African Law Society and our able moderator, Effie, and Francesca, the co-panelists, John, Baluto, and Nasser, and Gabriel. This was quite an insightful session, and also for the quite engaging, quite an engagement from the participants. I'm looking forward to carry this conversation forward, and have a good afternoon. Thank you.
Thank you very much, speakers. I'll also Miss Francisca, the lady of the house. So you have the last chance to put in a closing remark before we hand over to Gabriel. You are on mute. Can you hear Mr. Nasser?
Yeah, I can. We can hear you well.
Oh, we cannot hear you, Miss Francisca. You are either on mute or you cannot hear us. If you can, please just do your closing remarks in a minute. Then you can hand over the session to Gabriel. Very well. I think Francisca is having difficulties hearing us. At this point in time, members, I want to thank you for making time you make the session worthwhile. If we only had the speakers without the members, it would definitely not be a very good session or enlightening. But at this point in time, Gabriel, a number of questions are coming back to you, whether you will share the presentation, and people asking who is Gabriel. So as I close, I just want to hand over back to you and thank you for making this possible. We remain ever so grateful for the opportunities to learn, and we look forward to another very interesting session to learn about East Africa and how we can work together for the betterment of everybody. Thank you very much. Over to you, Gabriel.
An incredible session to see that all our 150 plus participants have stayed on till now shows exactly how much they value this discussion. And as I draw this communication to a close, I would like to reiterate my profound gratitude to you, our esteemed panelists, for enriching this webinar with your expertise and your insights. Indeed, without your participation, our esteemed panelists, this session wouldn't have been as insightful as it is. So we would like to thank you, our thought leaders. We are very grateful to you, Mr. Alphonse Gura, our keynote speaker, Ms. Francesca Kakoza, Mr. John Baluto. It's been an absolute pleasure. And Mr. Nasa Serunjoji, it's really been amazing drawing from your wells of wisdom on this particular subject matter. Now, this would not have been possible without our very able moderator, Miss Effie Acheng Sheila, who has kept us on our toes. You've kept us engaged. It's been really amazing. I love the conversation that has been going on in the chat room, and I think perhaps as a society now we will be moving towards organizing physical in-depth training on insurance law, because I can tell that it is gaining lots and lots and lots of traction from the questions that we have been receiving from our end. So we'd like to express our sincere thanks to you all. Thank you for making time to be part of this session. And as we end, a recording of the session will be shared on your different email addresses so that you can pick out a topic that you could have probably missed in the course of having this session on. So, ladies and gentlemen, on Thursday, we'll be having yet another very interesting session, and we'll be unlocking educational opportunities with UNICAF. We'll be delving into that special partnership that the East Africa Law Society signed with UNICAF in a bid to promote professionalism and the legal education prowess of members of the society. So you do not want to miss that session, because there is quite a lot to unpack, in particular how you can access a UNICAF sponsorship to pursue advanced studies, either at master's level or at doctoral level. So you want to attend that on Thursday. And then next week, we have a very interesting subject that is curbing tax-motivated illicit financial flows to reduce reliance on foreign aid in Africa, and what is the role of lawyers. So this discussion will be happening. It's powered by GFI and Youth for Tax Justice Network Uganda. So with those few remarks, ladies and gentlemen, allow me to wish you a very, very lovely afternoon. Thank you for keeping high numbers at the session, for your participation. We thank you, and we wish you a very lovely afternoon until we interact again. You stay blessed, and feel free to visit our website at www.eastafricalawsociety.org, like our social media pages, and follow us on Facebook, follow us on LinkedIn, follow us on Twitter. And wish you all a very lovely afternoon. Goodbye.